My name is Hakeem Walker. I'm the Administrative Director of Program on Lead Profession, and I see that sandwiches are gone and everyone's quieted down, so I figured it's a good time to get started. Thanks very much for coming to our weekly speaker series event. We do these every Tuesday, preferably in the same room if we can get it. But today we have a very special guest, Aditya Singh, who is a 2011 graduate from NALSAR University of Law, 2012 graduate from Yale Law School, and we're also pleased to say a former Student Empirical Research Grant recipient. You can actually see some of those opportunities listed here around the classroom. Feel free to grab one. Aditya also actually works with the Program on Legal Profession on our GLEE initiative, working with some of the faculty and other research fellows to do some work on legal education. And today we are fortunate to have Aditya up from New York, where he now works as an associate at White & Case. But though he works there as an associate at White & Case, these views today are those of his own and not of the firm. So without further ado, Aditya.
Thank you, Hakeem, and my thanks also to David, Eric, Nicola, and everyone else at the PLP for this opportunity to really get feedback on what is a work in progress. This event is particularly special to me because my association with David and the PLP has been the springboard for my interest in studying the structure, norms, and practices of the Indian legal profession, from interviewing faculty and surveying students at the many law schools in the various states of India, to interviewing virtually every senior partner at most notable law firms in the 5 major cities in India. Your support has made all of that possible, and I want to acknowledge that. All right, so let's talk about the passage or the lack of it to the Indian legal market. And let me begin by giving you a sense of what the next few minutes will look like. I'll start by giving a very broad and general introduction to the Indian legal profession, about law practice in India, and address why India matters to global law firms. I'll then confront the debate around whether foreign lawyers should be allowed to practice law in India. And my objective here is to basically describe and assess the many arguments for and against foreign entry. And I'll try to provide a framework for understanding and evaluating this debate. Next, I very briefly address the regulatory landscape, a bird's eye view of the laws that regulate Indian lawyers today, and then try to trace the judicial stance. How have Indian courts looked at this issue, and what are the kind of arguments that are put forth before Indian courts? Then briefly flag the experiences of global law firms in other countries, and talk about how liberalization of legal services has been structured in the different economies. And then before I conclude, I'll discuss how foreign law firms are currently servicing Indian clients on Indian transactions and disputes without being in India, and what are the possible ways in which entry could happen in the coming years. So let me begin with a brief introduction about the Indian lawyer. Not long ago, the idea that Indian lawyers would be business advisors to big corporations or be negotiators and mega deals might have seemed laughable. The Indian lawyer was simply a courtroom advocate. Most lawyers restricted their practice to a single court, and there were very few lawyers working in small law firms established in large cities prior to independence. And that was basically it. But in 1991, India began liberalizing its economy, and there was an increase in demand for legal services. But more importantly, because of the increased complexity of commercial transactions, legal services could no longer be restricted to advise on resolving disputes in court. And therefore, as foreign businesses explored the Indian market and Indian businesses sought partnerships with these foreign players, the definition of legal services in India changed to include advice on transactional and general business laws, on negotiating businesses, navigating risks, and the various regulatory hurdles that exist in the Indian market today. Today, the Indian legal sector is amongst the most dynamic in the world. In 2011, it was estimated to be worth $4 billion and forecast to grow to $6.5 billion by 2006. But let me not get ahead of myself, because the Indian legal profession today continues to be dominated by the solo practitioner, the litigator in India. For a majority of Indian people and even members of the legal profession, being a lawyer in India means being a solo practitioner litigator or working in a small firm doing court work. And to put things in perspective, numbers are helpful here. India has close to 1.3 million lawyers who are registered with the various state bars. In addition, there are 400 to 500,000 law students across the country, with 60,000 students graduating each year. Compare this to the number of lawyers working in major law firms in India. If we were to just add the number of lawyers working in the top 40 law firms in India, spread around 138 offices in more than 10 cities, the number comes to 3,800. And so the idea is to just point out to you that much of this conversation about entry of foreign law firms and globalization of the Indian legal profession, we're still looking at a tiny fraction of Indian legal work. But as you know, times are changing. Corporate spending is expected to rise in the coming years. Despite slow growth in the last year or so, India remains an FDI hotspot. And add to this the constant clamor about the leaping Indian tiger, the new global economic order, and all this, the great India growth story and the potential for rise titillates global law firms. And so, much like multinational accountancy firms, the big four that entered India post-liberalization, there is an increased demand that foreign law firms be allowed to enter India, but they face stiff opposition from major Indian law firms. And I'll come to that debate right away. So this is really, for me, the most interesting bit of this discussion. As you can see, I've identified 7 relevant stakeholders. And I'm liberal with categories, so you'll see some overlap. But what's important here is that the government is really at the center of this debate. And I say this because more than this being a legal or an economic debate, I believe that this is a political debate. And therefore, those who believe that the courts can come in and resolve these issues have false expectations, and I'll come to that in due course of time. But let's begin with the first stakeholder, the government, and let me begin with a couple of quotes. Basically, from the current law, from the law minister who was until October in charge of affairs, who basically said that I leave it to the Bar Association or the Bar Council, but this is something that you can't really resist given that everything else is being opened up in India. And the Department of Commerce in India also saying that this is something that should happen. But on the issue of allowing foreign law firms in India, the government has always found itself in the middle of a political minefield. So it was in 1991 for the first time when the government proposed that the market be opened up. And a lot of lawyers protested, courts were shut. And as a result, the proposal was shelved. And since then, successive governments have followed the same strategy. They've paid lip service to the principle of liberalization, but have successfully tiptoed around the issue long enough for it to become a problem for the successor government. And the question that really I want to ask is that, is the government overestimating the political volatility of this issue? Because remember, the people who really get affected by this are those 4,000 odd people. Very recently, India took a decision to allow foreign direct investment in the retail sector, which was met with a lot of debate. And the government's position was in danger. And there is this skepticism that the government runs into trouble every time there is a proposal to open up the doors to foreign players. But transactional lawyers, or even just lawyers in general, while being a powerful part of the society, are a small part of the electorate. And there is definitely the question that we need to ask about how politically unviable a decision on this can possibly be. Next, let's look at what clients have to say. And these are some interesting quotes. So first, from the General Counsel of the Tata Group, as you know, one of the largest companies in India, possibly the largest. When foreign law firms promise a document by a certain deadline, I have yet to come across an instance when they have failed to deliver, something which happens with alarming regularity with Indian law firms. They are pathological about meeting deadlines. It's not fair that we want foreign investments, but not foreign firms. Another quote from the General Counsel of General Electric. And so these quotes tell us the story that most multinational corporations and businesses in India welcome foreign law firms' entry because they simply hope that competition will improve the quality and there'll be competitive prices. Clients will have a broader set of firms to choose from. And while they currently engage law firms based in New York, Hong Kong, Singapore, and London for foreign work and for advice on foreign law, they'll be able to do it more conveniently in a location which is working in the same time zone. So on this point, there has been a bit of debate about quality. The question is, will it really improve? Are Indian lawyers who've been servicing big corporations coming into India for a while now, how much will quality really change? And in my view, the answer is that the market will answer the question for itself. If foreign firms cannot cater to the specific Indian law requirements, or clients will shy away and basically they'll be forced to shut shop. And similarly, if Indian law firms can't compete, cannot replicate the knowledge management systems, then the harsh realities of international lawyering will basically force them to rise up to the challenge. A worry for clients, however, is, and this is what came across when I spoke to some general counsels during my interviews, is that foreign firms may come into India, use their financial muscle and their large size to lower the price of legal services in the beginning, thereby eliminating competition, setting a lower price, but later on, once it's done, setting their own price and making it difficult for businesses to meet their demands. The next category that I want to look at is what I call Indian big law. These are basically large Indian law firms, many of them promoter-led or family-based law firms that control the large share of top corporate legal work. And this is an interesting quote from the president of the Society of Indian Law Firms and Interest Group in India, who basically says that the legal profession is too sacrosanct to be polluted by deep pockets of foreign governments or foreign lawyers. We are not into the business of law. We are a profession, and our profession is not for sale. So let's talk about how much of this is actually playing out. These groups are obviously the most vociferously opposed to foreign entry because they stand to lose out on a lot of business. But as is clear from Bhasin's "The Indian Legal Profession is Not for Sale" pitch, one of the major arguments is that foreign law firms would corporatize law and make law into a business and not a profession. And I think it's hard to agree with this argument because Indian firms are increasingly operating like businesses themselves and are therefore corporatizing law in their own way. Similarly, the argument that deep pockets of foreign firms will pollute the sacrosanct Indian legal profession might also seem unconvincing because foreign law firms are advising Indian clients on foreign law. They are engaging with domestic firms to advise their clients on Indian law. And so they are in many ways already in India. To be fair, however, there are some valid arguments that the Indian big law raise. For example, today Indian law firms operate under severe restrictions as compared to their foreign counterparts. For instance, Indian law firms are not allowed to freely maintain their websites. There's a limit on the number of partners that you can have. And that's the argument that most of these people make, that if the government is to allow entry of any sorts, you have to level the playing field. And in my view, while this is absolutely true, but this could also give a great opportunity for regulatory reform to take place in India, because if the government was to allow foreign firms to come in, then you would have the playing field would have to be leveled given the disparities that exist at the moment. The next group that I want to talk about are what Jayant Krishnan in his forthcoming piece talks about peel-off lawyers. And these are mostly first-generation lawyers who have worked for one or more of the large firms, but have moved on to set up their own shops for a range of reasons, including the limitations of upward mobility because of the promoter-led nature of these firms. And this group largely favors entry of foreign outfits, and that's something that's very clear from this quote from a founding partner of a law firm which was set up 13 years ago by a group of National Law School alumni who had all worked in different large Indian law firms. And many of these peel-off lawyers basically today feel trapped because of the existing family-based and proprietorship models where they believe opportunities for growth are limited. And this is, again, one of the key contentious issues. Happy to get into this in more detail during the discussion, but this comes up all the time in these conversations. Of course, if and when foreign firms were to come into India, they would attract some of the best transaction lawyers working in Indian firms. And in fact, many of the lawyers we spoke to said they hope to get poached by foreign firms when they come into India. And so inevitably, the folks who will be hired if foreign firms were to come into India are those who are culturally in tune with India, who have trained in Indian law schools and are familiar with Indian law. And this group is going to gain from any kind of entry, and therefore a lot of people already starting up law firms, setting themselves up as acquisition targets so that when the market was to open up, they could possibly be absorbed by one of the large firms. The next group that I want to talk about are the litigating lawyers and the local bar associations. So as mentioned earlier, lawyers across the country protested when the law minister in 1999 spoke in favor of liberalization of legal services. And this is really strange because the litigating bar, especially the bulk of lawyers that argue in district courts in the vernacular, should be the most unlikely group of opposing people, because after all, foreign firms have time and again stated that they're interested in the corporate transactional side of legal work and not in litigation. Contrary to their expectations, these lawyers stand to gain from entry because they will have to be engaged by foreign law firms to do court work. And so what is the reason why is it that the litigating lawyers in India, that powerful lobby, actually opposes entry? And if the reasons they give for opposing the entry of foreign law firms are implausible, are there better explanations for this protest? And Jonathan Gingerich has this hypothesis, which I want to flag because I think it's interesting, because he points out that it's possible that practicing lawyers deeply dislike the transformation of a law from a profession that was primarily oriented towards appearing on behalf of clients in courts to a business that dispenses legal advice and pursues big profits. So foreign firms are a unique source of pressure on the traditional Indian legal culture. And while big Indian firms have in many ways already been significantly leading to the disintegration of traditional Indian legal culture, these foreign firms will place unique pressures on them. All right, let's talk about what are obviously the flag bearers of the pro-liberalization lobby, global and large foreign law firms, who are constantly looking to expand their operations overseas. And India has, together with Brazil and China, always been on top of their agenda. However, Indian foreign firms have not had much success in getting government representatives and bar associations to effectively lobby with the Indian government. As opposed to the US government, however, the government of UK and the Law Society of England and Wales have lobbied the Indian government quite unsuccessfully, I must add. And in this section, I basically want to just ask the question if the interest in the Indian market that's attributed to foreign law firms is often exaggerated, because most firms are happy with the present arrangements where they work for foreign clients on India-related transactions indirectly. In the long term, however, the sense that one gets is that these firms are likely to get more ambitious and do what they have done in other countries, open full-fledged offices in India and advise both Indian and foreign clients. Finally, let's come to a group that's most often unrepresented in these discussions, law students. There are 900 odd law schools in India, and there is really a massive gap between the first 30 to 40 law schools in India and the rest. To put things in perspective, the top 40 odd law firms rarely look beyond the top 25 or 30 law schools in India as they hire. And therefore, I want to underscore the fact that it's hard to say where the definitive Indian law student stands on this issue. For instance, when I interviewed law students in my home city, in Meerut, which also has most law schools affiliated to it, none of them or their seniors had ever worked in a top 30 Indian law firm. So for foreign law firms, they didn't really care about it. So I think that's the primary view of the large majority of Indian law students. But most law students at elite Indian law schools are in favor of admission of foreign law firms. They believe that the entry will increase salaries, it will create more jobs, that there will be better training. And since there is a lot of talk in India about the family-based or proprietorship models of law firms, you will have more merit-based part-to-partnerships. And as a result, in the last 5 or 6 years, a lot of Indian students have increasingly accepted training contracts from a large number of UK firms. And in my conversations with students in my interviews, the one thing that came across was the one reason they wanted foreign firms to come in was while they were excited about the opportunities of working in a London or a New York and getting international exposure, they believed that there were certain social costs to moving abroad. And if foreign firms were to come into India, those would be eliminated. All right, from this debate and assessing the views of the many competing stakeholders, let's look at what is the regulatory landscape. And I have that chart only to point out that currently the Advocates Act, which was a legislation which was passed in 1961, regulates the legal profession. As per this act, any person who is a citizen of India, has attained the age of 21 years and obtained a law degree from a recognized university is entitled to be admitted as an advocate. And then this act goes on to say in section 29 that only advocates are entitled to practice the profession of law. The difficulty is that the act does not define what it means to practice the profession of law. And so does it mean to practice the law in India is practice restricted to litigation, that is appearance before any courts, or does it also regulate corporate lawyers doing transactional work? And these questions have been at the center of the legal debate around the entry of global law firms. The government has now proposed the Legal Practitioners Bill, which is still being discussed, and this includes qualified lawyers who are not just practicing in courts, not just advocates, but also doing legal services in their chambers, transaction lawyers, and if this was to be enacted, then this could change the course of the legal debate around entry of global law firms into India. How have the courts in India interpreted this issue? In the early 90s, a few foreign law firms opened up liaison offices in India, a move that was challenged by Lawyers Collective, which is a public interest organization. And after 13 years, the Bombay High Court finally gave a judgment interpreting the term practice of law and said that it included both transactional work and litigation, and therefore foreign law firms were not allowed to come in and do either. This did not really have much of an effect apart from the fact that these firms closed down their offices, but a majority of firms that were in joint alliances or best friend agreements continued to practice the law in the way they were. And why I think this case is significant is because, and I'll come to this also in my conclusion, because it gives an insight into what the government's legal position on this issue is. Because during the arguments, the Council for the Union of India informed the court that the government was currently in the process of consulting all relevant stakeholders and that any decision would only be taken after considering the competing views. Then came the A.K. Balaji case in the Madras High Court, where in March 2010, a lawyer from Tamil Nadu filed a petition challenging 31 foreign law firms and LPOs and basically claiming that they were illegally practicing law in India. And the court, in a decision in February last year, held that foreign law firms or lawyers cannot practice, again, litigation or transactional work, but it clarified that they could fly in and fly out and advise their clients on foreign law. And then the court made an important distinction between litigation and international arbitration and said that given the government of India's position that it wants to make India into an arbitration destination, foreign lawyers could come in and practice international arbitration. Clearly, it left both sides dissatisfied, and there's currently an appeal pending before the Supreme Court. But as I've said before, I think whatever expectations that people have from the Supreme Court are really ineffective, are false expectations, because this is not a legal debate. The Supreme Court is working with the 1961 legislation, which was enacted at a time when the nature of legal services in India was very different. And so I don't personally expect a lot to come in from the Supreme Court decision. Comparative lessons. How are global law firms expanding elsewhere, and how can we learn from their experiences? An interesting quote from a senior Brazilian lawyer who basically says that, we have great opportunities, but you can't let the guy who wasn't invited to the party to come in and steal all the sweets. And that's the sentiment that one hears from a lot of senior Indian lawyers and in other countries as well. And when you look at these different jurisdictions and how they've structured their legal market liberalization, we find that there is no clear pattern that emerges from global experiences, that there is no formula. For example, in Brazil, foreign lawyers and law firms are allowed to open offices and operate as foreign law consultants and advise on foreign law. In China, foreign lawyers can advise on international treaties, international commercial law, and law of the country in which the lawyer was admitted, but not domestic Chinese law. But China is a great example of a country where there is lax enforcement and there has been de facto liberalization. The European Union has a liberal regulatory regime for legal services for member states. And then there's Japan, which has allowed local and foreign lawyers to enter into joint alliances, to enter into mergers, and has attracted a number of American, British, and Australian law firms to target its legal market. Of all these countries, I find Singapore is an interesting and a good case study. In 2006, based on the recommendations of the Justice V.K. Raja Committee, Singapore has permitted foreign law firms, and there are a few interesting points about the Singapore model that I think I should highlight. First, while foreign lawyers can't do litigation work in India, the Raja Committee allowed foreign lawyers to practice international arbitration in India, something similar to what the Balaji court or the Balaji case in the Madras High Court does. Secondly, Singapore introduced a qualified foreign law firm, the QFLF program, which basically permits foreign law firms to enter the Singapore market to practice Singapore law in commercial matters only through the direct hiring of Singapore-trained lawyers from within the country. And to secure a 5-year license, foreign firms have to go through a process. They have to project their revenue and provide other information. And while the jury is still out on the implementation of these recommendations, Singapore is definitely one jurisdiction which has tried different methods of entry in the last few years, and something that Indian policymakers can certainly look at. Coming to the penultimate part of my presentation on how global law firms are currently servicing the Indian market and how they can, in the future, if the market was to open up, service and do India-related work. So let me come first to what's the current position. And there's an interesting quote from a partner at a major law firm in India who's basically saying that, call it what you will, in many ways Indian law firms are already here. So currently there are 3 ways in which large global law firms have India practices. The first thing is that they have India groups or India desks in foreign offices. And these are based mostly out of London, Singapore, Hong Kong, or New York, and are usually headed by a partner who has some ties to India. In some cases, these are people who were trained in India and then came to the US for their LL.Ms and stayed back. In other cases, these are simply people of Indian origin with family ties. And these groups staff a number of associates, many of whom are directly recruited from Indian law schools. I have put here the list of firms from the American Lawyers 2011 Global 100 survey to just show how most major firms in the top 15 have either got an India group or they have a second form of engagement with Indian law, which is through best friends agreement or referral arrangements. And they've been in news quite a bit now, and Professor Nanda's forthcoming piece on this issue is I think, does a great job of pointing out some of the challenges and opportunities of Indian firms and foreign firms coming around and entering into these agreements. And finally, it's the third method is for foreign lawyers to fly in, check into a hotel, advise their clients on foreign law, and go back. Finally, how, and I don't want, and this is something that comes up all the time, I'm asked, so when do you think the market will open up? And frankly, I don't know. And I don't want to speculate on when legal market liberalization in India will happen. But I do want to do some crystal ball gazing on how it could possibly open up, looking at the experiences of other countries and how the accountancy sector in India opened up a few years ago pursuant to GATS. So the first would simply be direct entry, the India office. And even within this, there could be separate ways in which this could be done. The first thing would be that the government could allow foreign law firms to set up an office that is entitled to do both transactional and litigation work in India. In my view, it's highly unlikely that this will happen in the near future because the litigating lawyers are going to rise up in protest, and not only is therefore this a politically unviable option, but even foreign law firms have time again said that litigation and court work is something that they're not interested in at the moment. A second option would be for foreign firms to come in where they could practice Indian and foreign law, but no litigation. And this is something that foreign firms are deeply interested in. But again, this is an option that would face opposition from the large law firm, which I described earlier as the Indian big law. And the third option would be to allow foreign law firms to set up independent offices, but only to practice international commercial arbitration or the law of their home jurisdiction. And this would be similar to, in many ways, the Brazilian position or the Singapore position prior to Singapore adopted the GLEE model. The second option would be to have joint venture or affiliate offices where foreign law firms would be allowed to come into India and open up an office as a joint venture with a local firm. And if this was to happen, this is something that's been tried in Singapore. There would again be several questions. For example, would the GLV be allowed to practice Indian law or only foreign law? Would it be able to engage in litigation? And would the local law firm be able to have an independent office? And this is something that has been tried in the accountancy sector. The big four in India, E&Y, KPMG, PwC, and Deloitte, all have offices. And the way it works is that, for example, an Ernst & Young has a huge office in Delhi, which does consultancy work. But most of their audit work is done by a small firm, which was established many, many years ago, called S.R. Bartley & Company, which does its audit work because Ernst & Young does not hold an audit license. All right, so I have a couple of minutes left. In conclusion, where do we really go from here? Globalization is not only redrawing boundaries, it is really profoundly changing the structure and the landscape of the legal profession. And the question really is that, is India's policy of protectionism in the legal market consistent with its aim of playing an important role in the global economic arena? And I think to settle this political debate, any change in the current position will require an amendment to the Advocates Act, and the government has to build consensus amongst the relevant stakeholders. And because I work at an international law firm, I will not take a particular stance on this issue, but I will point out that irrespective of whether the firm decides to allow entry or not, what's really harming the reputation and the market right now is the indecision. Let me give you an example. In 2009, in July, in response to a question in the parliamentary debate, the law minister basically said the following, and I quote, that the issue of allowing foreign law firms to establish their offices to give legal advice and assistance in foreign law is being discussed with all the stakeholders, and we will soon come out with a decision. This was July 2009. In December 2009, the Bombay High Court, in the Lawyers Collective case, in its last paragraph, makes the following observation, and I quote again. Counsel for the Union of India had argued that the central government is actively considering the issue relating to the foreign law firms practicing the profession of the law in India. Since the said issue is pending before the central government for more than 15 years, we direct the central government to take appropriate decision in the matter as soon as possible. Following this decision, in March 2010, the law minister yet again responded in Parliament by saying that the government was studying the implications of the Lawyers Collective decision and was in consultation with the Bar Council of India and the relevant stakeholders. So in July 2011, I filed a right to information petition similar to a FOIA request in the US. And my questions are very simple. I didn't want to know what the decision was. My questions were, what is the current viewpoint of the government? Who are these stakeholders that you're consulting? What is their view? When did you have meetings? Where were these meetings held? Who attended these meetings? And in August 2011, I received a reply which basically said that a decision on the issue of entry of foreign law firms will be taken after receiving comments from stakeholders which are still awaited. In 2012, I again filed another RTI, and I'm still awaiting a response on that. And I'm saying this to basically make the point that the indecision, a term which is often used about the Indian government these days, policy paralysis, is really leading to great uncertainty. And irrespective of the choice they make, Indian policy makers must take a decision and end the uncertainty. Even a draft proposal, setting up of a committee, which we're really good at generally, will go a long way in resolving this issue. Thank you so much.